takers?
Well, first on the question of the assumption, your assumption is correct that first of all, the United States was asked to take measures to see to it that New York State compensated the workers, and the United States sees itself as not having the means to do so because under a federal system, the Constitution allocates certain rights to the central government and other rights are reserved to the states or to the people themselves under the 10th and 11th Amendments and so forth. So I don't want to get too technical. I want to make a point that goes to the question the brother just asked, and I'll come back to the other question, about large institutions and how do you deal with this. There is a labor lawyer whose work I respect a lot, in addition to Staunton Lynn, named Carl Clare. And the observation that Clare makes is that one of the things that labor law does, and that law generally does, but labor law especially because it deals with workers, is that it channelizes all sorts of actions, and by doing so, in these procedures and in these modalities that have been developed under law, in doing so, it prevents and it tamps down and it suppresses worker self-activity. And what Daniel, I think, was getting at is that the old model relied on worker self-activity and relied on solidarity. And what happens is, as large institutions form and become bureaucratized, everything gets channeled in a certain way. The grievance, as Daniel pointed out, is owned by the institution, not even owned by the worker. The institution will decide whether to pull the trigger, proceed with the grievance, take the grievance to arbitration. Those are not decisions of the workers. So one of the things that I think needs to get transformed is worker self-activity in solidarity needs to be brought to the fore again, and we need to be more questioning of all of the channelizing that goes on under the labor law regime. Okay, so that's important to understand. Now, on the question of a fact sheet, a succinct fact sheet is doable, and this is a fairly simple kind of thing. I would like to give you the decision itself from the ILO. There are any number of paragraphs that can be the basis. I suggest that this be that you take the decision and have it be part of a committee activity so that people understand what it says and can reduce it to a page. And you can imagine what that page is like. What happened with the strike, the unions attempting to go to the international fora, the result and the pronouncements of the fora, and the fact that very little has happened. Part of it is that people don't know about it. And so I've spent about a year or so working on this. I want to leave you with one thing. Back in the Cold War, when it was the Soviet Union and the so-called free world, in fact, the free world called its union confederation the International Confederation of Free Trade Unions to distinguish them from the communist unions, you see? And the litmus test of a totalitarian state was that the unions had no bargaining rights. So the ideology in our country was, a totalitarian state when you look at their unions and you see that they don't have bargaining rights. And last year we saw in our country an attempt all across the country to strip the unions of the bargaining rights. So that's a sort of ironic way of understanding what has gone on. Are we going to descend to a totalitarian regime because the unions have no bargaining rights? Well, the flip side of that is, many unions do have bargaining rights, but what do? As Daniel points out, they sign a clause in the contract that says, during the term of this contract, we promise we will not strike. Okay? And even if the employer violates the contract, the Supreme Court has said, you still can't strike, but they violated the contract. So why can't we violate the clause where we promise not to strike?
Right.
And the Supreme Court, in the Boys Market case, said, no, you can't. You have to grieve, and you have to, go to arbitration, and you have to utilize all these procedures. These procedures, I think many of us understand, many of us who are labor lawyers understand, are a kind of trap that undermines the self-activity of workers by channeling all of these activities into bureaucratic, legalistic forms. So that's the tension. Good luck with the vote,
Yeah.
but
What happens then?
what happens then? And so there has to be an effort to keep thinking about these things, and one of the things about the Occupy movement is its innovativeness. And one way to start innovating is to think about self-activity within and possibly outside of the legal regime.